For years, the series of legal cases surrounding Donald Trump has followed a familiar pattern. Whenever a court got close to making a decision that could cause real harm, the process would be prolonged by appeals, procedures, or legal arguments so complex they paralyzed progress. The public gradually formed a sense that no consequence was final, that any risk could be indefinitely postponed. But the moment that just occurred has completely shattered that perception. For the first time in this entire saga, a federal court has imposed an immediate legal consequence that cannot be dodged with familiar delay tactics or appeals. The almost panicked reaction from Trump's legal team shows the severity of this moment. This is not just an isolated ruling, but a sign that the justice system is beginning to draw a clear line where the game of delay is no longer effective. The crux of this turning point lies in the role of federal judge Tanya Chutkan, who is presiding over the case related to the events of January 6th. In the American justice system, not all judges have the same level of influence on the broader legal process, but her position here is particularly significant. She is not new to this file. She has been monitoring the entire chain of delays, disputes, and legal tactics for months. Therefore, her decision does not stem from a spontaneous reaction, but is the result of a long-term cumulative assessment. More importantly, she understands the symbolic nature of the case. Any move will be scrutinized not just by the parties involved, but also by other courts and national public opinion. In that context, this ruling is not merely a procedural decision, but a declaration about the limits of judicial patience. What makes this ruling particularly dangerous for Trump's defense team isn't found in harsh language or dramatic pronouncements. On the contrary, it is delivered with a cold precision that leaves almost no room for emotional debate. In the federal court system, such decisions often carry far more weight than ostentatious orders. For a long time, the narrative spun to the public was that Trump was constantly gaining the upper hand. As cases were delayed, charges were dismissed, and the scope of immunity was expanded. This ruling has completely fractured that narrative. Instead of continuing to allow the process to be drawn out, the judge has activated a procedural mechanism that Trump's legal team had tried everything to avoid for months. There was no loud bang of a gavel, no grandiloquent language, but the impact of this decision is direct and difficult to reverse, laying the foundation for an entirely new legal landscape. To understand why this decision has put Trump's legal team on the defensive, it's necessary to clarify the concept of discovery sanctions in the federal justice system. In both criminal and civil cases, the discovery phase is when parties are obligated to exchange, provide, and preserve relevant evidence. This is not a privilege, but a mandatory duty to ensure a fair trial. When a party is found to be obstructing this process by delaying, concealing documents, or failing to preserve evidence, the court has the power to impose sanctions. Discovery sanctions are not symbolic. They are the court's official conclusion on a procedural violation, and they bring direct consequences during the trial process. Unlike setting a trial date or issuing orders that can be stayed pending appeal, discovery sanctions often take effect immediately. Once applied, they shift the procedural balance in a way that is very difficult, if not nearly impossible, for the violating party to reverse. The key element that makes discovery sanctions so dangerous is that they are nearly impossible to erase. When a judge issues a sanction accompanied by findings of fact, those findings immediately become part of the official judicial record. They are not sideline remarks or temporary opinions, but recorded written conclusions that exist permanently within the system. Even if the case is delayed or goes through rounds of appeals, these findings remain, influencing how other judges, other prosecutors, and even future juries view the matter. For Trump's defense team, this means a crucial door has closed. There's no longer an ability to wait it out, nor is there hope that procedural issues will simply disappear over time. The legal consequence has been fixed, and all subsequent moves must revolve around that reality. Among the consequences that discovery sanctions bring, an adverse inference is the most devastating element for a defense strategy. At its simplest level, an adverse inference allows the court to instruct the jury to assume that the evidence that was concealed, lost, or not provided on time would have been unfavorable to the violating party. In other words, instead of the prosecution having to prove the content of those documents, the legal system allows the jury to infer the worst about them for the defendant. For Trump's legal team, this is a fatal reversal. For months, their primary strategy was based on delaying, arguing about privilege, and dragging out the process of providing documents. Now, the very gaps created by that tactic have become a tool against them. Every unfound email, every withheld document, every extended deadline can be interpreted by the jury as proof that something damaging existed but was hidden. For many years, the tactic of delay has been a familiar part of how Trump and his legal team have dealt with legal challenges. Dragging things out not only helps to wear down the opposition, but also creates space to reshape the public narrative. However, this ruling has completely reversed that logic. Instead of providing an advantage, each day of delay now increases the legal burden. Documents not provided on time, ignored requests, or justifications about privilege all become grounds for applying adverse inferences. This turns a tactic once considered effective into a double-edged sword. The defense team can no longer control the pace of the case as they wish. Every effort to prolong the process now directly strengthens the prosecution's position, tipping the procedural scales further in a direction they do not want. The clearest sign of this ruling's severity lies in the almost immediate reaction from Trump's legal team. Just hours after the decision was issued, they filed an emergency motion with a tone markedly different from their usual confident arguments. Instead of focusing on refuting the legal basis of the ruling, the motion's content primarily revolved around arguing that the consequences imposed by the court were too severe and improperly timed. In the world of litigation, this is a significant signal. When lawyers stop arguing about the right or wrong of the law and start complaining about the severity of the consequences, it shows they are acutely aware of the damage the ruling has caused. The language in the motion is not one of control or proactivity, but one that reveals concern and urgency. For those accustomed to observing major cases, this reaction indicates the defense team understands they have just lost one of their most important defensive tools. From the prosecution's perspective, this ruling was not a surprise, but the result of a strategy prepared very early on. When the case related to the events of January 6th was initiated, prosecutors understood they would face a wave of delay tactics, from disputes over executive privilege to complex procedural requests. Instead of just focusing on building a case based on evidence that could be presented at trial, they simultaneously recorded and archived every act of obstruction during the discovery process. In the federal justice system, procedural obstruction is not just a matter of professional ethics. It's a factor that can create its own legal consequences. Therefore, every time a document was delayed, every request not met on time was treated as a link in a larger file. When the time was right, that file became leverage, allowing the court to intervene in a way that changed the entire state of play. To fully understand the weight of the sanctions that were just applied, it's necessary to look back at historical precedents where discovery sanctions completely changed the trajectory of a major case. The Enron prosecution is a prime example. When faced with massive fraud allegations, the defendants in that case also used familiar tactics, delaying the provision of documents, citing technical reasons, and claiming that much electronic evidence was unrecoverable. The court ultimately concluded that there had been destruction and concealment of evidence, thereby applying an adverse inference. The consequence was that the practical burden at trial was reversed. The jury was instructed to assume that the lost documents contained information unfavorable to the defendants. The experience from Enron shows that when an adverse inference is applied, conviction rates soar, because juries often view the concealment of evidence as an indirect admission of guilt. This lesson explains why the current ruling is seen as a turning point with the potential to determine the outcome. In his ruling, the judge did not offer general observations, but clearly identified three key groups of obstructed evidence that are crucial to the case. The first group relates to communications with alleged co-conspirators in the period immediately preceding January 6th, a decisive time frame for proving coordination and preparation. The second is the failure to retain and preserve documents at the Trump Organization, raising serious questions about internal processes and the awareness of legal obligations. The third is the deliberate delay in providing privilege logs, which prevented the prosecution from timely assessing which documents were genuinely protected and which had to be turned over. Each of these evidence groups is directly tied to the core elements of the indictment, from conspiracy and intent to the awareness of wrongdoing. Their obstruction is no longer a secondary issue, but has become the focus of a new legal battlefield. The most direct and profound consequence of these sanctions is the reversal of the burden of proof at trial. Under normal circumstances, the prosecution must prove the specific content of each document and communication to convince the jury of the elements of the crime. But when an adverse inference is applied, that requirement fundamentally changes. Instead of having to reconstruct what was concealed or lost, the prosecution is permitted to rely on the act of obstruction itself to ask the jury to draw an inference unfavorable to the defendant. This not only saves prosecutorial resources, but also creates a significant strategic advantage. The gaps that the defense team once considered a safe zone now become circumstantial evidence of intent, coordination, and awareness of wrongdoing. In this context, the defendant faces a new reality. The more evidence is missing due to their own actions, the weaker their position becomes before the jury. The scales of justice have tipped in a way that is difficult to reverse. The significance of this ruling does not stop at the confines of one case file or one courtroom. When a federal judge makes detailed factual findings about a pattern of obstruction, those findings immediately capture the attention of other courts monitoring related cases. In the American justice system, judges rarely operate in complete isolation. They observe, consult, and learn from how their colleagues handle similar situations. The fact that a court dared to apply strong sanctions in a case of national importance creates a clear ripple effect. It sends a signal that behaviors once considered legitimate tactics are approaching an unacceptable boundary. For other ongoing cases, especially those involving the same defendant, this ruling becomes a crucial point of reference. The legal landscape thus begins to shift not only vertically within a single case, but also horizontally across the entire system. Behind the technical analyses and procedural consequences, this ruling carries a broader message about the rule of law. For years, the public has witnessed a sense of asymmetry where those with power and resources seem able to bend the legal process to their will. Rules were treated like suggestions. Deadlines became objects of negotiation, and the obligation to produce evidence was endlessly prolonged. This decision directly challenges that reality. By applying sanctions that are effective immediately and tied to specific factual findings, the court affirms that the law is not optional. The core principle is reaffirmed. All parties in a legal proceeding are held to the same standard, regardless of political standing or public influence. This is a moment when the system sends a signal that the law's patience has its limits, and when those limits are crossed, the consequences will be real and immediate. This ruling carries a clear message about how the justice system views the rule of law in the context of immense political power and influence. For many years, the public has questioned whether procedural rules are truly applied equally, or if they are only strict for those with fewer resources. The judge's decision this time directly answers that question. By imposing sanctions with immediate effect, the court affirms that the obligation to comply with the law is not a matter for negotiation. Citing one's status, role, or influence cannot become a shield against the basic rules of a fair trial. This message is especially important in a context where public trust in institutions is eroding. When a court is willing to apply the law firmly to a powerful individual, it not only resolves a specific case, but also reaffirms the operational foundation of the entire legal system. Before this ruling, the strategy of obstruction and delay was often seen as a beneficial calculation. Every day the process was extended could weaken public attention, pressure the prosecution's resources, and create opportunities for external political or legal changes. However, this recent decision has completely reversed that calculation. Instead of minimizing risk, the act of obstruction now directly increases the legal costs for the defense. The sanctions applied are not merely financial or procedural, they also weaken the foundation of the defense before the jury. Each delay is no longer a neutral move, but becomes an adverse factor officially recorded in the case file. When the cost of non-compliance exceeds the benefit of delay, the old strategy loses its appeal. This forces the legal team to reevaluate its entire approach in the upcoming stages. After this ruling, Trump and his legal team are caught in a clear dilemma. If they choose to fully comply with the court's requirements in the next phase, It would mean indirectly admitting that previous delays and disputes were unjustified. That belated compliance might lessen future sanctions, but it would strengthen the argument that their prior strategy was based on obstruction rather than the protection of legitimate rights. Conversely, if they continue down the path of delay and defiance, the legal consequences will become increasingly severe. Sanctions could be expanded, and more adverse inferences would accumulate in the record. Whichever path they choose, the defendant's position has already been weakened. There is no longer a safe escape route as before. Every decision now carries a clear legal price, forcing a fundamental change in defensive strategy. One of the most notable long-term consequences of this ruling is its potential to become a template for how other similar cases are handled. When a federal judge has clearly established the legal reasoning and application of sanctions for obstructive behavior, other judges have a stronger basis to do the same. This is particularly important in the context of Trump facing multiple cases at different levels and jurisdictions, from criminal to civil. Each court can now look at this precedent and realize that applying strong sanctions is not only lawful, but also necessary to protect the integrity of the judicial process. Once a template is formed, the tactic of delay is no longer a safe option. Instead, it becomes a risk that could trigger a chain reaction, weakening the defendant's legal position simultaneously on multiple fronts. Beyond Trump as an individual, this ruling sends a direct message to all defendants who possess significant power, money, or political influence. For years, there has been an unspoken belief that with enough legal resources, anyone could game the system by dragging out time, complicating procedures, and wearing down the will of the opposing side. This recent decision shows that this belief is no longer as certain as before. When obstructive behavior is officially recorded and linked to direct consequences at trial, the strategy of out-lawyering the system loses its core effectiveness. Skilled lawyers and large budgets no longer guarantee the ability to control legal proceedings if basic obligations are violated. This message is especially important for corporations, politicians, and other powerful organizations that are watching closely to gauge the true limits of judicial tolerance. For many years, one of the most dangerous consequences of prolonged and delayed cases has been the erosion of public trust in the fairness of the legal system. When people witness powerful individuals repeatedly avoiding clear consequences, the prevailing sentiment is that the law is only truly strict for those who lack the resources to defend themselves. This ruling directly challenges that cynicism. By applying specific and immediately effective sanctions, the court sends a signal that procedural rules are not optional and no one is above these basic obligations. Restoring trust doesn't happen with a single decision, but moments like these carry great symbolic meaning. They show that the system is still capable of self-correction when pushed to its limits, and that the rule of law is not just an abstract concept, but a principle that can be enforced even in the most sensitive of cases. After all the analysis and with the consequences laid out, the biggest question remaining is not whether Trump will have to face them, but whether the justice system can maintain this momentum of accountability moving forward. A ruling, no matter how powerful, is only truly meaningful if it does not stand alone. The coming months will show whether other courts, other judges, and other levels of the judiciary are willing to follow this approach. Pressure from politics, the media, and public opinion will certainly mount, testing the resolve of the system. However, what has changed is the strategic calculation. When obstruction no longer brings benefits and instead causes direct harm, the motivations for all parties involved begin to shift. This moment, therefore, is not just the end of a delay tactic, but could be the start of a new phase, where legal accountability is no longer an aspirational concept, but an enforceable reality.